Further, the Leonard MacDonald AJP said at 5:30 to 5:31, it is important to bear in mind that a ruling on admissibility is not final. Relevant evidence led in the main trial may be taken into account by the judge or magistrate when reviewing his decision on admissibility, no matter what the source of such relevant evidence might be. There is no reason why this should not also be the position when a trial within a trial is held. The Leonard Shoes, Judge Shoes, in the case of S versus Muchinindu, 2002 SACR 313, Witwatersrand. A ruling on admissibility on a trial within a trial is interlocutory and may be reviewed at the end of the trial in the light of later evidence. The principle in itself shows that subsequent evidence in the main trial may decisively affect the determination of the issues in the trial within a trial. And if subsequent evidence may, why not also earlier evidence? Right, with that caveat, let me add the case of S versus Ntuli, 1993 to SACR 599, Witwatersrand. It's a judgment on appeal which was before Zulman and Nugent, who in my view are some of the most brilliant judges this country has produced. Now, having the caveat of what Sotetsi says, I'm going to read in full what these judges say. Accordingly, the only reason advanced in the judgment for admitting the confession was that the evidence given by the appellant was unsatisfactory. The evidence which he relied upon, that is the magistrate, for reaching this conclusion was all given after the confession was admitted and it related to the contents of the confession rather than the alleged coercion. The evidence relating to the coercion had been given during the trial within a trial and was not scrutinized at all. It is difficult to see in those circumstances on what grounds the magistrate admitted the confession in the first place. The magistrate appears to have been under the impression that a confession may be admitted during a trial, provided only that at the end of the trial, the evidence as a whole is sufficient to justify the admissibility. The admission of a confession on the basis that evidence may later emerge to justify its admission would, in my view, constitute a gross irregularity and reduce the procedure for determining whether a confession is admissible to nothing more than a charade. The admissibility or otherwise of a confession falls to be determined on the evidence placed before a court in a trial within a trial, together with the admissible evidence which has gone before it. If at the end of the trial within the trial, the requisites for admissibility have not been proved, the confession may or must be excluded. It cannot be admitted on the basis that other evidence may emerge during the course of the trial to justify its admission. Once a confession is admitted, its admission is provisional only in the sense that evidence may thereafter emerge which requires it to be excluded. Then it goes the case of R. Malozani, 1952, 3 SA 639, that's 644E. It's an AD case. The other case is S versus W, 1963, 3 SA 516, Appellate Division. And the other case is S versus Zameni, and another 1971, 1 SA 807. Right, that is the law. So it mustn't be argued that this judge didn't consider the evidence regarding coercion. In other words, the synopsis of the encapsulation of the evidence, the salient features are this, that when the state intended to bring into play by introducing the so-called alleged confessions or statements of accused number 1 and 2 and the pointing out by accused number 2, the defense objected. And the principal objection was that, 1, they did not make statements. They did not make confessions. They were told to sign documents which were fully completed, and they were told sign here, sign there, initial here, initial there. That was the initial defense. The second defense is that they were assaulted, tortured, severely, as Mr. Mgomezulu put it, severely tortured, choked, electrocuted, kicked, in order to elicit their signatures on the documents. In other words, these accused before court, their evidence is they don't know the contents of the confessions. They don't know. They were never read to them. And if you go further, accused number 1, for instance, says when he went to sign the confession or statements before Maboto, I think, Maboto never even sat down. When Maboto came, they were assaulting him. All that group of policemen. And Maboto then called him aside and said, hey, you know what? Why don't you sign this document? These guys are going to injure you. And then, to save his life, accused number 1 says he signed. No discussion with Maboto in an office sitting down, according to accused number 1. Accused number 2 also says when he went to sign the alleged confession or statement before Mrs. Kronje, all he said when he got in, even before Mrs. Kronje could introduce herself as a magistrate, he came in and told Mrs. Matlaping, the interpreter, that, may you tell the lady, please, that 6 weeks I haven't had a bath, from the 16th of June, I think. And also that I want to speak to my daughter, I want to speak to my partner or parents. And that was it. And he sat down and looked at the ground. And Mrs. Kronje, what he did was he was busy with his computer. She never asked him anything. All she was interested in was the computer, and then she would get out and gossip with a fellow magistrate or fellow white lady and come back. Mohono was going in and out, consulting with Mrs. Kronje. Nothing was discussed between accused number 2, and Mrs. Kronje, except, as I said, that I haven't had a bath and I want to speak to my daughter and my partner. Nothing. The same applies for Rapudu. Accused number 2 says, no discussion with Rapudu, nothing. He was just beaten up and told to sign. So in the main, that is the salient aspects of the evidence relating to the trial within a trial. It's obvious that Keninda, Maholewa, and others gave evidence. But what I want us to understand is that this court, after careful analysis of the evidence adduced by the state, and after careful analysis of the cross-examination interposed by the defense against the evidence adduced by the state, and after careful analysis of the rebuttal evidence of accused number 1 and 2 and the cross-examination interposed by the state, and after careful analysis of the heads of argument by all the parties concerned and the verbal submissions made by all the counsels in this court. I have dealt, not like this magistrate did, I've dealt with all the evidence relating to whether the said alleged confessions were made freely and voluntarily in the sound and sober senses of the deponents without any force or coercion. I've dealt with all that, and I've also dealt with the other primary defense by the accused, that all the accused were not apprised of their constitutional rights, meaning section 35(5) of their rights. They were never apprised according to that. And this court even also interrogated that. And as we all know, section 35 encapsulates the concept that if any evidence is acquired through the infringement of the Bill of Rights, that evidence should not be admitted into the record of the proceedings relating to section 1(7) and section 1(8), even section 1(9) of the Criminal Procedure Act. Right. Consequently, after going through all that evidence carefully, this court has reached the following conclusion. One, it rules that the confession made by accused number 1 was made freely and voluntarily without any coercion when accused number 1 was in his firm, sound, and sober senses. 2, the confession made by accused number 2 in respect of the said confession being taken by Mrs. Ronje, the magistrate, the court rules that it was made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. And also the confession made before Colonel Rapudi was also made by accused number 1, 2. Freely and voluntarily without any coercion when he was in his sound and sober senses. And also the pointing outs made by accused number 2 before Colonel Khadebe were also made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. Okay, that is the ruling. Yes, Mr.
My Lord, may we perhaps adjourn for a short while just to have a plenary meeting with my colleagues as to the conduct of the proceedings going forward.
Okay, fine.
We discussed that briefly just before we resume this morning.
So how long do we adjourn?
I think about 15 minutes should do.
Okay, 15 minutes.